Third, I'm sorry. What is third? Third. This is Manus, now, it's called pointillism, Manus. Pointillism. It's not a bad technique, Manus. It makes it for specificity and a certain amount of clarity. It may not always be. It is liable for some intellectual property protection also, Manus. Correct.
So more than anything, you will know where you are going.
Now, Manus, the third one is para 110 of Quixote, which your Lordship has seen right at the beginning of the Navam Rebia arguments, but Lordship may kindly be reminded of that. Just turn to 110.
Or judgment compilation.
Judgment compilation. Or basically, Malus, the very strong constitution bench injunction when the jurisprudence of 10th schedule was starting. Quixote is, Malus, virtually the first. I mean, there were some cases, virtually the first, certainly the first constitution bench and the most important 10th schedule judgment at that time. Malus. They started this jurisprudence with this great warning and mandate. PDF 134 or 74? 74. 74, the Kyoto starts at 134, para 110. The full thing is quoted here. In view of the limited scope of judicial review, may I read it?
Yes.
In view of the limited scope of judicial review that is available on account of the finality clause in para 6. So, Lordship gives basis for it, finality clause in para 6. And also having regard to the constitutional intendment and the status of the repository of the adjudicatory power. Speaker, Chairman, judicial review cannot be available, mark these words, cannot, Constitution bench is saying, cannot be available at a stage prior to the making of a decision by the Speaker, Chairman, and a quia timid action would not be permissible jurisdictionally, threshold, nor would interference be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate and irreversible repercussions and consequence. But I'll just pause here. It has some very startling consequences. If your Lordship reads this, it's a constitution bench. It makes only one exception. When I, the Speaker, by an interim order disqualify you, that has happened hardly ever. Well, this happened once or twice, but it is not really happening in the 10th schedule. Maybe that will be a new technique adopted in the future, well, I don't know. But today, well, it's hardly any case. But
you are giving the idea.
No, but Quixote gave that idea. Quixote has given the idea already, but that's why I'm saying from 92 till now, it has not happened despite Quixote's idea. I mean, it may have happened one or two cases, but hardly ever happens. Yes, Kuldeep Bishnoi case, etc. But well, in that exception apart, it is per se jurisdictionally bad. So therefore, a perceived error of the Speaker's conduct will not justify your interlocutory application. That's important. Let us assume that the Speaker is wrong. Nobody is conceding that. Let us assume that the Speaker is grievously wrong. That will not justify circumventing of a constitution bench by saying, normally we will not interfere, but here, by a matter of degree, I opine that he is grievously wrong, therefore we will interfere. Well, let's take an example. Your Lordship has applied that example for decades. It is not something strange at all. Quixote was, according to me, saying the obvious in a much more important category. Your Lordship is done it for lesser category. Well, as your Lordship finds genuine problems in an election process. When an election process starts, your Lordship finds genuine cases. My nomination rejected badly. I was stopped at the door by a guard. I couldn't enter. Somebody obstructed me. I couldn't file in time. This man is rejected on a comma, full stop, wrong ink. They are very compelling arguments. Your Lordship says, come after the election. In 99% cases, unless there's a special statute. Because you don't interdict an autonomous, self-contained scheme of a code there to let elections go on. Here, a much higher constitutional authority to allow unfettered proceeding further. There are many more examples the Lordship has. Therefore, the position which by a combination of the positive and the negative order inevitably led to the change of government, possibly was also constitutionally wrong. Had your Lordship had occasion to discuss it in the 2 weeks following that, your Lordship would have rectified it. Today, it cannot be a bar merely because of passage of time, because this is on the face of it contrary to your Lordship's constitution bench. And an error of the Speaker was irrelevant. In fact, he hardly had opportunity to commit many errors except perhaps of the 2-day notice, that would have been decided. I've cited lots of members, 2 cases I cited in the Navam Revia, where 3-day notices were sufficient. Yedurappa and, Yedurappa was the other way, was Nayak and Balasa, Patil. Srimant Patil. Three judges, 3 days, sufficient. When the rule said 7 days, I hope my Lord remembers that well. In Navam Revia, I cited those cases to your Lordship. Rule said 7 days, 3 days notice. 2-judge bench in Ravi Nayak said okay. 2-judge bench in Yedurappa doubted it. 3-judge bench subsequently affirmed the Nayak principle, despite noting and citing Yedurappa. Then, Malas, the 4th facet is that the more important and the more general principle, but equally important, that your Lordships respects co-equal organs. There's a whole other line of cases. When I come to my notes, I've cited some of them, where your Lordships is very careful, because your Lordship now doesn't think of an individual speaker, but of the institution, where your Lordship doesn't enter into co-equal branches unless there are compelling reasons. So respect between and mutual balance between judicial and legislative organs is the other legal principle which has to be kept in mind, and all this goes towards making the non-interference principle at that interlocutory stage. Then the other facet which your Lordship in case law has used is, there may be a rarest of rare exceptional situation where your Lordship passes interim orders, not in this case, no case, I'm saying generally, now I'm not going to tension you, to maintain a status quo. But your Lordship is very, very sensitive and cautious and careful to create a new status quo by an interim order. Maintaining a status quo and leading to the creation of a new status quo are two different principles of law looked at and dealt with differently by case law. Here clearly a new status quo was created. The 5th principle is actus curiae. Obviously, actus curiae arise in the event that your Lordship finds that I am partially right or fully right, not otherwise. But if your Lordship finds, then your Lordship reverses the most intertwined situations, because the Lordship never allows the act of court to do any harm. Actus curiae neminem gravibit. The 6th facet is that if there is a right made out, I'm sorry, my apologies.
No, 6.
Next. Actually, I dictated these later on, so my numbering is also in A, B, C, D, E, F, G, because the main submissions are below in 1, 2, 3, so I don't have those numbers. Okay. But your Lordship is right, I'll say next, your Lordship will have your own numbering.
Yes.
Well, is what your Lordship, I'm sorry, this is not that we are using Latin, your Lordship has warned us in recent judgments against using Latin, but these are basic principles. The other one, is ubi ius, ibi remedium. If your Lordship finds that I have a right, in this case a constitutional right, made out by all this which we have been arguing, then at the end of that right to say that I am remediless. The remedy which is effective and real is only a reversal of the status quo ante, as would stand immediately prior to the consequence of those 2 orders in June. The consequence being the change of status quo on 4th July? 4th July. 30th June is the swearing in. 30th June is the swearing in. I'm sorry, not 4th July, 30th June. So it must be a status quo ante. In the event that your Lordship applies the principle, obviously ibi remedium doesn't arise unless there is ibi use. If I don't have the use, I don't have the remedium. But on the assumption that I have, then your Lordship will not be told it's a fait accompli.
So what would then be the consequence, Dr. Singhvi? What does the court then, logically, what would be the directions of the court?
Well, logically, the direction is that that particular act of swearing in is wrong, and your Lordship will have the whole thing done again. Your Lordship could then, to give a Lordship, your Lordship give a substantive answer.
Yes. What will be the substantive directions then?
Yeah.
Now,
I am giving your Lordship a substantive direction. Of course, I will develop the law which is yet to come. In the event that that is correct, and that is the majesty of the law, that is what your Lordship means when your Lordship demolishes 25-floor buildings. And the message goes that your Lordship is ultimately establishing the supremacy of the law. Supremacy of law is by no other means except by result. by actual de facto on the ground result. The rest remains, Malas, paper and words. It would be, Malas, a reversal of that oath. I'm being very, Malas, formal and constitutionally proper. A direction.
Oath is on 3rd.
No, I thought 3rd, Malas, is 30th. I also thought 3rd, that's why I said 3rd. Apparently it's on 30th.
Because on 29th...
That's right.
night he
That's
resigned.
correct. That's correct.
Of course, Thackeray
That's
resigned on 29th evening.
That's correct. Doesn't matter, 3rd or 30th, but reversal of the day before that. Second, well, for the purity of the process, your Lordship will, there is still a Deputy Speaker, should decide what he would have decided but for Lordship's injunction. Because your Lordship is now counting the status quo ante on the but for test. But for these two orders, what would have happened? Obviously, only this would have happened. There would have been no swearing in and there would be a decision. Well, it sounds sometimes difficult, but imagine. Yes.
So far is
Kindly note.
Dr. Singhvi.
Yes.
When you are on the interim injunction,
Yeah.
not granting interim injunction on 29th and to see that the status quo ante is maintained, it was only with respect to the floor test on 30th.
And he resigned. That's what, and Lordship is asking. No,
1 minute. You can read the... on 30th, on 29th, he resigned. The order dated 29th, not granting injunction was very clear. That the floor test on so-and-so will be subject to the... Floor test on 30th will be subject to the ultimate outcome. Correct? Now, in that case, correct, raise the question of status quo ante.
Yes,
correct.
I'm
on
very grateful.
On the basis of the 29th injunction or not granting injunction.
I'm very grateful for a query. Your Lordship has put it in a different way earlier. I must answer it again. It's very opportune at this moment. Malas, there are two answers. One answer I gave 3 minutes ago, Malas. Your Lordship's court is a court of substance. Always.